Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hard-working Americans and their families?
You will! This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefits in your benefit plan. Now prepare to learn,
Plan,
save,
and protect with the FIA Group.
Welcome to another episode of Empowering Plans. Today you have myself, Kelly Dempsey, along with Nick Bonds. We're both attorneys in the consulting department, and we're going to be talking to you about the unified agenda, all the things that the Biden administration wants to do in the next couple months before the election, all the different regulations that they're looking to continue to push forward and through. So let the record reflect that Nick is making me talk about politics and regulatory agendas, and this is not my favorite topic. So I'm going to be the best supporting actress here with the commentary that I offer. Well, I do offer a unique opinion and headspace from the fact that before being at FIA, I was actually at a TPA. So I have a little bit of experience there, enough to be dangerous to help kind of comment on how some of these things are going to impact all of our TPA clients. So with that, we have a lot to go through. We're going to try to go through a couple more things in a little bit more detail, but hit all the highlights of what is on this unified agenda for the next couple months. So I'll turn it over to Nick to start with our first topic, which of course is mental health parity.
Yeah, thank you, Kelly. I hate to twist your arm into talking politics, but you're kind of the perfect person to talk about this stuff from because you're so reluctant to get into it. You're going to give me unvarnished feedback, I know, on every aspect of it. But kicking off into the Biden administration's unified agenda, this is essentially a list of some of the biggest regulatory items that the administration wants to get squared away before the end of term and ideally before the election. So the big one here Kelly mentioned is on mental health parity. The Biden administration did release a proposed rule, I think last summer in July of 2023. We've been waiting for a while for that to be finalized because that's going to have a lot of implications for almost every group health plan we work with. Virtually every group health plan is going to be subject to the Mental Health Parity and Addiction Equity Act, but it's going to have to comply with the requirements to perform a comparative analysis of all the non-quantifiable treatment limitations, the NQTLs, that they're imposing on mental health and substance use disorder benefits. So the proposed mental health parity rules would kind of help us have a little bit more clarity on what the comparative analysis requires, how the NQTLs are meant to be analyzed. It also kind of highlights some of the big areas of focus that we know the regulators and the DOL are specifically looking at. Some of the big ones still are autism spectrum disorder generally, and limitations around things like ABA therapy and other treatments for autism spectrum disorder. We also know that eating disorders and residential treatment limitations are probably big bugaboos, but again, those are only parts of the proposed rules that we got to look at last summer. So we're waiting to see how those kind of shake out in their finalized form, which we'll hopefully get to see. I think the projected date to see those was August or September. We're recording this on Wednesday, August 28th. So there's not much left in August, but we could still see those come out next month. And that could have a lot of big impacts on mental health parity compliance and on our comparative analysis service that we offer to our clients too. But I think the next big thing on the list, Kelly, you might have a little better perspective on the surprise billing requirements.
Maybe, we'll see. So I know there's obviously been a lot of feedback, and we've seen just a ton of thoughts go into what's been happening, and from the medical provider side and the payer side, there's been a lot of feedback to the regulators about what is working and what isn't working. So there were obviously some proposed regulations that were issued way back in October of 2023 that would do a couple different things, including formalizing the open negotiation period and requiring specific information to be included, as well as some claims details to be included when those things are filed. Again, my non-educated opinion on this, it seems to be, a consistency issue of how we file things, and that each entity involved is able to identify the correct claims based on the information provided. And obviously with all the different claim systems and, healthcare systems, that every different hospital uses a different document record tracking and billing department, software and all the things. I think there's obviously an issue sometimes of identifying and making sure the correct claims are all included together. And, there was obviously some issues with the service codes regarding batched claims and what that means. And so it seems like there's a lot of feedback to try to improve the process. And it seems like, this would improve it for everybody kind of all around. So it's a good thing that, more consistency, more clarification on what that means. Again, these things are probably delayed again until November. So it'll be obviously an interesting time crunch to get this done by then. And the extra piece of this is the air ambulance services regulations are officially delayed until at least March of 2025. So obviously there's a lot up in the air and this is kind of, a situation we found ourselves in the last couple election cycles, that times are thrown out there, whether or not they meet those deadlines. It's kind of anybody's guess, but that's what's out there right now. So again, it's feedback, it's reactions and clarifications based on the feedback they've seen. The proposed rules have been hanging out there for quite some time. So I know there's been a lot of opportunity to provide feedback, which is good. So hopefully this helps everybody. And that kind of, I guess, leads us into a similar topic that, because of the fact that it's documentation associated with claims, but not necessarily the same thing. Again, different rules, but there's been a lot of thoughts about advanced EOBs, the explanation of benefits and what that means. So I'm going to turn it back over to you, Nick, to go through what that means, and I'll again give my color commentary on my thoughts and 2 cents from a TPA perspective.
Yeah, I'm sure all of our TPA listeners are going to have many, many thoughts about the advanced EOB requirements. If you cast your mind back to the end of 2021 when the CAA was passed, these were part of the transparency requirements that were put forth in that act. We thought they were initially going to be taking effect at the beginning of 2022, but they've sort of been deferred in their enforcement. But they are starting to rear their heads again now. And these, kind of like the surprise billing requirements, the regulations implementing these are expected in March 2025, which is maybe optimistic depending on how the November elections go and depending what the regulatory bodies look like come the beginning of 2025. These could get backburnered, they could get accelerated. We really can't say for sure which direction it will go. But just a quick rundown of the advanced EOB requirements. Essentially, healthcare providers are required to provide good faith estimates, GFEs, of the expected charges to furnish an item or a service that's scheduled for a participant. And if a group health plan receives the GFE or receives a request from a participant, they basically are given 1 day to provide the advanced EOB, basically giving the participant a disclosure of what to expect that scheduled service or procedure to cost. And anytime you see a timeline of 1 day, I think it probably makes a lot of people panic. But there are a lot of other specific requirements that kind of go into the advanced EOB. We do expect to see more details, and maybe some of these details would change in the final regulations. But Kelly, what do you think the TPA world out there will react to the advanced EOB requirement once it goes into place?
I mean, I think when the proposed rules came out in 2021, I think the initial reaction was, ugh. It was just kind of a big sigh, a big groan of, more steps in the process. Obviously, it goes along the lines of trying to be better for consumers, trying to help people understand what they're going to owe. It kind of feels like, at least from a documentation perspective, it kind of feels something like similar to like how the SBC was supposed to be a shopping tool. And, obviously the SPD and plan document are the details. And, we know that SBCs unfortunately aren't really used as a shopping tool. They're used truly as a summary of the benefits. This feels somewhat similar. Again, I agree with you that 1 day turnaround time is a little intimidating. But again, we're trying to make things better for the consumers and trying to get everybody on the same page. These rules kind of feel like it's being told everybody needs to play nicer in the sandbox together. That's just my initial reaction with that. I think it is important, again, from a transparency perspective, for people to understand and have a good faith estimate of what a service is going to cost and what the plan is going to pay. From a practicality perspective, I guess, providers and payers would probably view this as a little bit of an administrative burden because it's more documentation that's required. And, how will this work? Will this go forward? I don't know. In theory, it sounds very nice. In reality, it sounds like it's going to be a challenge. But, it works in certain industries. Like, I guess if you think about the dental industry, and when you go in for dental services, they generally provide you an estimate very quickly of how much your future services are going to need. If you need a crown, if you need a new tooth, a root canal, whatever it is, they're able to fit out what that is. And again, I know that dental services are much more limited and defined, I guess, than medical type services. There's obviously a lot more different codes and procedures in the broad medical space. So, I guess it's worth a shot. We'll see if it happens, but it definitely seems intimidating if you are the ones having to put these together and produce them and provide them. And again, it's a huge administrative, for lack of a better term, burden.
Yeah.
So is it going to happen in reality? I don't know. I mean, there's been all these rules about transparency and having prices disclosed, and, it's a game and we all have to figure out how to play nice together. I just don't know how realistic it all is.
Yeah, I think there is an aspirational element to some of these proposed regulations that we'll have to see how they get implemented in their final form. Kind of another potentially aspirational tactic that we're seeing in the regulations is attempts to just improve cybersecurity measures overall, and for HIPAA and PHI specifically. This is probably something that's born out of, some of the major hacks that we've seen in the industry that have caused leaks of PHI. I don't care who you are or how good you think your cybersecurity is, the potential for you getting hacked is never zero. And so the administration and the regulators are trying to put together regulations that they think could help mitigate some of the potential harms from PHI getting hacked and leaked in a cybersecurity incident. We do expect regulations on these to come out hopefully by the end of the year, probably sometime in December. And we expect that to kind of build off of some of the guidance the regulators have released already. They've posted, I think in February, guidance for covered entities and business associates around their PHI and their protection of electronic PHI, ePHI. And OCR, I know, has also released some cybersecurity resiliency plans. So they might be drawing from a lot of those different sources to kind of cobble together some type of privacy and cybersecurity regulation that could be, at the very least, an interesting signpost for groups. Again, we're going to have to wait to see how all of these regulations actually shake out in their final forms, but those are some of the big ones that we saw in the unified agenda. So the clock is ticking for the Biden administration before they turn back into pumpkins, but I know they're going to work on them as fast as they can, so we'll probably get to see some exciting new regs here before the year is out for sure. And then I think, Kelly, you'd mentioned some updates on the gag clause prohibition and some of the updates to the GCPCA.
Yeah, that's another acronym that I just love to say.
We've had a real alphabet soup this day, but that's just the cherry on top.
Yeah, there was an update to the user manual, which is not an unfamiliar territory. Every year when it comes to new rules and new forms and things to fill out, there's usually some sort of update to instructions. So we get updates to 5,500 instructions from time to time, and the same thing with the employer mandate forms, the 1095Cs and A's and B's and all those things. So no surprise, there were some updates to the user manual for gag clause prohibition. I had a client recently ask me if there were any changes, anything new for this year, and I stumbled upon this, that the user manual was updated, and I feel like I didn't hear that before. So not a whole lot of significant changes, but there are some clarifications related to filings and when one attestation is necessary versus multiple attestations. It really depends on the number of the plans the employer is offering and how those are filed. So if the employer files everything as a single plan, like with a wrap document under a single plan number, either 501, 502, 503, 504, whatever that number is, there's only one attestation needed. However, if the employer has multiple plans that are filed separately and distinctly from each other, so they have a 501, a 502, and a 503, they're likely going to have to file those separate attestations. Again, it's going to be very plan specific, employer specific, depending on how their structure is and how their filings are set up. That's one of the bright sides to, this system, is that however you file and set things up depends on how you file it. So there's wiggle room. There's not necessarily one right or wrong way. You just have to do it the right way for what you have set up. So that was short and sweet. And I know the next, I guess, bigger topic is, obviously there's been a lot of discussion about the Loer Brgh decision and how that overturned the Chevron deference. And there's been obviously a ripple effect of what overturning of that case and that doctrine means with respect to lots of different cases, but we have two specifically that we want to go into. So I'll turn it back over to Nick to talk a little bit about that.
Yeah, Loer Brgh, this is one of those, kind of sea change moments in federal administrative law, where when Loer Brgh came out, effectively, the Supreme Court threw out the concept of Chevron deference, which I know we've talked to death a few times already, but essentially Chevron deference meant that where a statute was ambiguous, the regulators had basically the leeway to put forth their own interpretation of the statute that they were enacting through regulations. And as long as their interpretation of that was reasonable, courts had to defer to their interpretation. Loer Brgh basically said, no more. Basically, now, if a statute is ambiguous, then it's up for the courts that are reviewing the regulatory action to decide whether or not the regulators had a reasonable interpretation. And if not, then any regulations they enact are effectively, stricken down. Now, that's being applied to new regulations that we saw come out earlier this year, trying to implement Section 1557 of the ACA, which is another topic that we've seen a lot of developments on. It's essentially the primary non-discrimination provision of the Affordable Care Act. It's largely come up most recently in the context of discrimination on the basis of sex. That was the big marquee part of the Bostock decision, basically saying that discrimination on the basis of sex includes discrimination based on gender identity, sexual orientation, sex stereotypes. And this is a set of regulations that have evolved basically with every change in administration. There were 2016 rules that were then overwritten by 2020 rules, which were then just now overwritten by 2024 rules, that basically two big cases argued under Loer Brgh that the new 2024 regulations could not be enforced. So a Mississippi court basically issued a nationwide injunction staying portions of Section 1557, the new regulations, staying portions of those from going into effect nationwide. And then a Texas court issued a stay blocking all parts of the new regulations in the states of Texas and Montana. Basically, the HHS tried to defend the new regulations, saying that this was them trying to update Section 1557 in the wake of the Bostock decision. The courts basically took the argument that these decisions did not deserve deference that they would have under Chevron. So basically, these regulations have been stayed, and I think that means that we effectively default back to the 2020 regulations to the degree that they aren't enjoined entirely under these new cases. So this is just one of the biggest examples I think we've seen of Loer Brgh being invoked to undermine regulatory action, but they will by no means be the last. I'm sure we're going to see many more federal regulations being challenged, arguing Loer Brgh and the lack of Chevron deference.
Yeah, this is a tough one for a lot of different reasons. And I know that, we've gotten a lot of questions about 1557 recently, and that's likely because obviously we also had a rule change. Again, modified rules were issued in April. Unfortunately, it's now a trend of every 4 years we've gotten some new rules related to 1557. So it's been kind of a saga of 2016 and then 2020 and 2024. But I think one of the important things when it comes to 1557 that everybody needs to keep in their minds is that mental health parity comes into play when we're talking about gender dysphoria and 1557 and gender affirming care. They're very intertwined, and we see a lot of situations and scenarios where it seems like we're trying to separate the rules, but this is one of those rules where it's really challenging to separate out because there's always going to be that mental health component when it comes to this. So this is a very challenging one. I know, I think sometimes people's eyes glaze over when they hear the words 1557 or mental health parity because it's been so out there repeatedly with everything that's happening, and there's this continued evolution and the non-quantitative treatment limitations. So it's a lot, and we know it's a lot, but we're here to help, and definitely make sure to keep that in mind, that when we are talking about 1557, don't lose sight of the fact that the ACA is obviously there, but then you've got mental health parity as well. So you've got multiple different rules and considerations, and even beyond 1557, if you're not necessarily a covered entity, the EEOC can still enforce certain discrimination issues against employers. So there's lots of different dynamics here, lots of things to keep in mind and keep in consideration. And I know we just went through a lot of different things that are on the agenda and on the docket for the next couple months. So where we thought maybe we wouldn't have a whole lot of changes coming up, that could change, unfortunately. It depends, and we don't know what our crystal ball is going to say. Nick, do you have any other kind of closing comments that you wanted to throw out there?
I would just say that, all these regulations, I know it's all kind of in flux. A lot of it will come down to the results in November. So just everybody stay buckled in. We'll keep our eyes on things. And yeah, any specific issues or specific questions that come up, please always feel free to reach out to the FIA group.
Yes, absolutely. Thank you so much for joining us, and have a great day. Thank you.